Today is March 28, 2011. This is Children and Justice. And we're going to be doing Learning Module 4. We finished 1 through 3 before the midterm. We've just gone over the midterm exam, and we're going to pick up with Learning Module 4. I'm going to talk to you now about the United States Constitution. And you might say, well, why do we need to hear about that? This isn't a law class in the sense that we're going to talk about the United States Constitution. We want to hear about children and justice. But in order to understand the next 4 cases that you've read already and that I want to discuss with you, you have to understand the United States Constitution, and more specifically, the 6th Amendment of the United States Constitution, to really have an appreciation about how kids are handled within the criminal justice system, how the criminal justice system deals with children in criminal prosecutions. Now, let's go back to the 18th century, before the American Revolution. We know that former British subjects came to the United States, or came to the Americas back then, and populated what later became the 13 colonies. And eventually there was a revolution, and the Americans established independence. When the American government was in its formative stages, when it was beginning, the people, represented by the legislators, created a constitution. And a constitution is really a contract. It's simply a contract. And it's a contract between 2 parties. And in the United States, that contract is between the citizens and the government. Those are the parties to that contract. So for all of the mysticism of the Constitution, and there are law school classes, there are advanced law school classes, there are thousands and thousands of books that attempt to interpret the Constitution. A large part of what the Supreme Court does is interpreting the Constitution. When you boil it down to its essence, the United States Constitution is simply an agreement between us and our government. It's a contract. We made a deal. We said, you know what, we're going to have a government. We don't want to live in a state of anarchy. We're going to have a government. But we want to make sure that that government lives up to certain rules and principles. And just so they don't forget, we're going to write them down. We're going to write them on a piece of paper. We're going to make them sign it, so to speak. This contract between the citizenry and the government is the United States Constitution. And this contract's focus, the focus of this contract, is on really one set of principles. And these principles all have to do with limiting the government's power over its citizens. And the specific principles, the specific paragraphs in this contract were inspired by, or motivated by, in nearly every case, by what happened to the people in England, before they came to the U.S. The people who populated the 13 colonies and then later 13 states. Many of them were first-generation Brits. Some of them may have been able to trace their lineage back a generation or 2 in the U.S. But all of the citizens were recently from Britain. And in Britain, government was oppressive at times. Government did not respect the rights of individuals as much as the colonists and the American citizens felt they should. Individual liberty was quite a different thing in England. And if you look at this contract, and you look at the paragraphs in it, specifically the amendments, you will see that nearly every one of them arose from something that happened in England that we didn't like. For example, one of my favorite ones, it doesn't come up that often, but if you get the Constitution, and it's not that long, it's not that difficult to read even. If you ever go visit the Supreme Court in Washington, or even the New Jersey Supreme Court, they have a gift shop in Washington. You can buy all kinds of trinkets and junk and take it home as a souvenir. You can buy a copy of the Constitution. It's maybe about 4x7, a little red-bound copy of the Constitution for $1.25. You can thumb through it, and there's the Constitution of the United States, the contract between the citizens and the government. If you look in there, one of my favorite sections is, there is a prohibition in the Constitution. I think it's in the Second Amendment. Maybe we'll look it up. I think it's in the Second Amendment. It says, the government is prohibited from quartering troops in your home. And what that means is, let's say that, we had an army moving and they were about to go off to Afghanistan to fight the war in Afghanistan. And they were traveling from a base in Georgia and they were coming through New Jersey. It's been a long night and they're coming past your house and they have nowhere to stay. And there's no bases around here. They come knocking on your door and they say, Captain Del Russo here. I got 11 infantrymen. How many bedrooms do you have in this house? What's in that garage back there? And you'd have to quarter the troops. You'd have to get out of your bed, and the soldiers would sleep on your floor. They'd sleep in your shed. They'd sleep in your house. And you were obligated to make room or space for these troops. Now, the American revolutionaries felt that it was important to have an army. They just felt it was a little too oppressive to have the army come by your house and ask for your bedrooms and sleep on the floor and take over your home during wartime. So there were no quartering of troops. More relevant to today, there are other contractual provisions in the United States Constitution. One is, there's going to be freedom of the press. You cannot tell the press what to print and not to print. The press has absolute freedom to write about the government, to write negatively about the government, to write whatever they want. That's not the way it worked in England. Sometimes people were arrested for saying things in pamphlets. Freedom of speech is in the First Amendment. People were arrested for standing on a soapbox and saying things against the king. You could be hauled off to a dungeon for speaking badly about the king. Not in the U.S. We made a deal. We said, you know what, we're going to have a government. The government can rule over us, and the government can take care of us, and you can tax us, and you can act for the benefit of all of us. But you will not tell us we're not allowed to say what we want to say whenever we want to say it. We're going to make a special line in the Constitution about that. In an amendment called number 1, we have the freedom to say whatever we want. We have the freedom to practice whatever religion we want. Not so in England. You have to be a member of the Anglican Church. And if you weren't, you were suspect. And in fact, if you said something contrary to what the Anglican Church believed, which was the Church of England, you could be charged with blasphemy, sometimes treason. Not in the U.S. We made a deal with our citizens. We said, you know what, we can worship whatever we want to worship. We have freedom of religion. Put it down, write it down, and make the government sign it. That's the deal. First Amendment. Freedom of assembly. First Amendment. Second Amendment. Right to bear arms. Controversial provision. What does it all mean? Does it mean you have the right to bear arms when there's a war? Right to bear arms to go fight some other government entity? Or is it the right to bear arms when you're walking through some nightclub in Belleville? You know? What does the right to bear arms mean? The bottom line is, one way that governments were oppressive to citizens in Europe in the 18th and 17th century was they controlled the guns and the weapons. And if you began to marshal your guns together and try to stand up for your rights there, they would come down on you swiftly and harshly. And they said, listen, we should be able to have a militia. We should be able to have a group of soldiers that protects these liberties that we all are agreeing to. So that's in the Second Amendment. Then you have the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Seventh Amendment, and all the amendments. That's the deal between the citizens. Between the citizens and the government. Now, when we get up to the Fifth and Sixth Amendments, these are the amendments that become relevant for what we're going to talk about today. The Fifth Amendment is the privilege against self-incrimination. The privilege against self-incrimination. And that says, and we're going to talk more about that later, especially in the context of the Division of Youth and Family Services and Child Protection Actions, and whether DIFAS workers are government agents or not, whether the Miranda rules apply. We'll talk about them later. But right now I want to give you an overview of the United States Constitution. And in the Fifth Amendment, we made a deal, and we said, listen, We didn't like the way they did things in England when they investigated crimes and brought you to trial. Now, in England, they had due process. They had a nice judge with a powdered wig. And they had jury trials. And they had prosecutions and defense lawyers and a robust and vigorous criminal process. But one of the things that they did was they forced you to make a statement. And if you wouldn't make a statement in your defense, they'd use it against you. They'd say, you got nothing to say, you must be guilty. And in forcing you to make a statement, they wouldn't yell at you or wave a finger at you or hit you with a notepad like NYPD Blue or something like that. They'd put you on the rack and screw. They'd torture you. They'd hurt you. They'd brutalize you until you made a statement. They would force you to be a witness against yourself. Well, we said, no way. That's not the way we're going to set up our government. We want a government that investigates crimes. We want a government that puts people in jail and punishes the wicked. But we don't want to do that at the expense of our ability to not be witnesses against ourselves. We don't want to live in a place where they force us to make statements. So that's where you get the Fifth Amendment. The privilege against self-incrimination. No one can force you to make a statement. You have the right to remain silent. That statement from the Miranda Rule is based upon the Fifth Amendment constitutional provision, and that, as I started out by saying, is a product of our negative experience in England. When I say our ancestors, negative experience in England. Fourth Amendment, unreasonable searches and seizures. We want the government to be able to search for stuff that might prove a crime. We just want it to be reasonable. We don't want people to search us just because we're African American, or just because we're tall, or just because we're Asian, or just because we drive a funny car, or we're not wealthy. We want there to be probable cause. There's got to be some basis for the government to search our stuff. And we just didn't think up that thing. And we just didn't say, well, that might be a problem. That was a problem. That was a problem in England, and in Spain, and in Italy, and in Ireland, and throughout Europe, where they could search your stuff arbitrarily. And we said, that's not the way we're going to live here. Write it down and sign it. That's the Constitution. Wonderful document. It's, like I said, it's really little. But it has some important things in it, things that are dynamic and living, that survive the ages, and that you can apply to modern factual scenarios too. Moving on to the Sixth Amendment. The Sixth Amendment has the right to an attorney and the right to confront the witnesses against you. The Sixth Amendment has the right to an attorney and the right to confront the witnesses against you. I want to show you a video clip few video clips today. That illustrate these points. So you have the right to an attorney, and that right applies not only in the adult courts, but also in the juvenile courts, as we learned from Ray Galt. And some people find it controversial that people get free attorneys, and attorneys are there just to trip people up or be mouthpieces for guilty people. That's not the way it works. It is important that even criminal defendants, even the people in that case with the dead child, even people who are obscenely guilty, even the man who shot the congresswoman out in Arizona, deserve representation. Nobody should be prejudiced in this country. No one should be prejudiced because they're not smart enough to understand the law. No one should be hauled into a court proceeding and be at a disadvantage because they don't understand how to represent themselves. But that's the way it was in England and in Europe in the 18th and 17th centuries. And we wanted to make sure that it didn't happen here. We wanted to make sure that people were represented, by someone who understood the process and the law. Wouldn't it be sad if we had a government where they would haul us to court and maybe we weren't completely innocent, but we're innocent of some of the charges, or maybe we were completely innocent, or maybe we were completely guilty. But wouldn't it be sad if we couldn't present a case because we didn't understand the law, or we didn't know how to respond to the court? It would be like putting you in a football uniform and putting you out in the middle of the field and saying, play football. You don't know anything about it. You don't know any of the rules. You don't know why you're wearing equipment. You would just get pulverized by the other side. At the very least, one ought to understand the process and be well versed in the process if you're going to be held accountable by that process. So, to have an attorney levels the playing field. Why should anybody else be at an advantage because they're smarter or they have a more thorough knowledge of the law? So the Sixth Amendment, with regard to the right to counsel, is the great equalizer. And it's important. And the citizenry made a deal with the government after the American Revolution, and they said, listen, you can govern us, but if we get hauled before a criminal court, you have to give us a lawyer so the playing field is even. The other thing, and the thing that leads us to the examples of children within the justice system and how the New Jersey Supreme Court and other courts have attempted to level the playing field to make the courts more hospitable for children, is this Sixth Amendment. Now, the Sixth Amendment says generally you have a right to confront the witnesses against you. Okay? That's the magic phrase that you need to remember. You have the right to confront the witnesses against you. Lots of things arise out of that phrase, out of that constitutional provision. But like all of the other constitutional provisions, from freedom of speech to freedom of religion, to quartering of troops, to the right to possess arms, to the right and privilege of self-incrimination, all of them arose from our negative experience in Europe, and specifically in England. This one had to do with being hauled off, charged with offenses, and not being told what they were, and then being convicted without knowing who your accusers were. And that happened in England all the time. And it happened throughout Europe all the time. So when we settled this country, and after the revolution, we said, listen, we're going to have a government. We want to make sure there's a robust law enforcement and criminal justice system. We want to keep bad guys locked up. We want to be safe. But we don't want to do it at the expense of our liberties, our ability to have a lawyer, our ability to not be forced into making statements. And we ought to know who's accusing us of something. And more importantly, arising out of that, we ought to be able to challenge that person. We ought to be able to look that person in the eye and ask questions. That's the Sixth Amendment. Now, this is a clip from a film about probably the only woman that Henry VIII truly loved, Anne Boleyn. The problem was that Henry began to become suspicious of Anne Boleyn, and he fabricated charges of incest and treason and charged her. And this was the kind of thing that happened in England with some regularity before the 19th century. And you will see how the Sixth Amendment's right of confrontation is so important to the revolutionaries in America. You'll see how that constitutional right was not something that the English believed in at that time. And here Anne Boleyn is before a court in England, and she's charged with incest and treason. It's an all-male tribunal. The charges have been filed by the king himself, and she is, I think, Henry's third wife. And the one thing about her that makes her a fascinating historical figure is she was kind of headstrong. She was a feisty queen, and not one to mind her tongue, and she was someone who stood up for her rights. And this is a pretty good clip. This actress is, she's Tim Burton's wife. I forget her name. Helena Bonham Carter. Yes, thank you. She does a nice job.
Master Kingston, bring in the prisoner.
It's a sad day when the nobility of a country does not stand for its queen.
Even sadder when that same queen is charged with adultery and incest.
Yes, charged is different from convicted, Master Cromwell. Or is it not in this court?
Charge is that between the 24th and 27th year of the reign of our sovereign Lord Henry, King of England, his wife, the Queen, having been seduced by the devil, did knowingly commit adultery.
How do you plead?
Not guilty, my lord. Further, as queen, I challenge the right for this court to try me at all.
On what grounds?
They are not my equals.
I caution Her Majesty against such arrogance, when we have a mountain of evidence against her.
Correction. A mountain of lies.
I have countless statements from witnesses sworn under oath.
Well, then either these people have perjured themselves, or you obtained your statements with the Reckonines.
Does the Queen presume to call me a liar?
With greater justification than you call me whore.
My lord, why do you tolerate such disrespect? I have here 100 pages of confession that show the Queen has committed fornication, high treason, and matters of a sexual nature so offensive to God.
Well, then can we not read these statements? And where are these witnesses? Are they not present so we can hear them for ourselves?
They're condemned. We will not insult His Majesty by admitting their evidence in his court.
Why not? You insult him far more with the perversion of justice that is happening here in his name.
I hardly think this Queen is qualified to speak of perversion.
Silence.
My noble lords, if what I fear is true, namely that you have condemned me already, well then my testimony is of no value. But allow me, for the sake of the record and my conscience, to say this. The love I have for my brother is the love any sister would have for someone with whom she's grown up, nursed when sick, played games with as a child. And that is the love I have for him. As for these other gentlemen, I have no more been their lover than I would lie on my own daughter's life. I admit that I have not always borne towards the king the humility that is fitting. I admit that I have been jealous. And I admit that I failed to provide him with a son. But as God is my witness, I have not betrayed him in any other way. That is my word. You must put it to your consciences.
My lords, the time has come to cast your votes.
Guilty.
Guilty. Guilty. Guilty. Guilty. Guilty. Guilty. Guilty. In which case the burden falls on me to pass sentence. Anne, Queen of England, you have been found guilty of treason by this court. It is therefore my duty to sentence you to be burned or beheaded at the King's pleasure.
You can see there was no Sixth Amendment in Anne Boleyn's trial, right? I mean, they had stacks of statements. She couldn't see them. She even asks, well, who are these people? Why can't I look them in the eye? I mean, this is all about the Sixth Amendment here, at least the center part of her reaction to the jury. The last person who pronounced her guilty, by the way, was her brother, who helped arrange for her marriage, as I recall.
So they killed her? They beheaded her?
Yes. Yes. Now, what does this have to do with child abuse? What does this have to do with leveling the playing field for children? Well, every one of the cases that we looked at in Learning Module 4 involves the Sixth Amendment right to confrontation. And in fact, if you listen closely there was a little bit of the Fifth Amendment thrown in that clip. Can someone tell me where the Fifth Amendment was involved? Something she said about the nature and quality of the evidence involved the Fifth Amendment, not the Sixth Amendment. The right not to be a witness against oneself. What did she suggest about the statements and who they came from and how they were secured?
Those were not her kids.
Well, that was in the beginning. She said that about the jury, but about the people who made statements.
She wanted to cross-examine them?
She wanted to cross-examine them. She wanted to ask them questions. And she said that you probably got these statements from, she said, I'm sorry? Well, she said something about the rack and screw. She said something about being tortured. It's a term of art, you may not have put it on there. But she talked about the turning of the screw or something like that, about that these were the product of torture, that they were compelled statements. She makes a statement about that. In the very beginning of the clip where she says, "You are not my equals," that's her being feisty when she says, why aren't you standing? There's two things happen. Later she says, "You're not my equals," but she says, why aren't you standing? Why are you all seated? She says, "It's a sad day for England when you don't respect your queen and stand up." And they say, "You're charged with these offenses." And she says, "In my book, charged does not mean convicted. I'm still the queen, you need to stand up." And they all reluctantly stand up. And then she challenges the jurisdiction of the court by saying that only the king can decide her fate, not this tribunal, because you are not my equal. She is part of the divine right of kings, or at least somehow related to it in that way. But in any event, the Sixth Amendment involves the right of confrontation, the right to look at those statements, the right perhaps to look at the witnesses against you right in the eye. And that's where we come to New Jersey and some of the rules that govern children in the courtroom. Okay? Now, you looked at a number of cases. We're going to take a look at the Crandall case first. Now, I know you wrote the Crandall memorandum about closed-circuit television, right? You wrote a memorandum suggesting that Wendy Ruth ought to be able to testify via closed-circuit television. And you based it upon the lessons of the Crandall case and the statute that the Supreme Court talks about. How is the Sixth Amendment involved in the Crandall case? What does Anne Boleyn and what she just told this courtroom about the witnesses against her, what does that have to do with some kid testifying on closed-circuit television in the criminal courts in New Jersey? Go ahead.
It's two sides to the coin, but as far as Anne Boleyn is concerned, it's kind of on the same plane as the alleged perpetrator wanting to see the actual children testify so he can see, or I guess have a visual of who's testifying against him. But the other side is protecting the child's rights and making them comfortable with testifying about their alleged abuse.
You summed up the Crandall case rather well. On the one hand, you have the right of the defendant to observe the witnesses against him. In that case, it was a man with a female child. But you also had the trauma that the little girl in the Crandall case would have experienced had she had to look at her father from the witness stand, and the emotions that would be associated with having to testify in court in the presence of the defendant. So the court had to do a balancing act.
So the TV was the medium between the defendant seeing the victim, but the victim didn't have to see the defendant, and she's still protected from the trauma that she may have maybe seen by seeing the actual perpetrator.
That's correct. The television monitor allowed the defendant to watch the little girl testify. And she got to testify from some other area in the courthouse. And she didn't have to look at her father during her testimony. That was the ruling of the case. But the defense lawyer said, that's not good enough. I don't like that result. What did the defense lawyer argue? He said, there's a Sixth Amendment issue here, and it's important. And we're not treated like Anne Boleyn was treated anymore. We have a contract with the government that says we have the right to challenge the witnesses. We have a right, even more important. What's the word that's in the Sixth Amendment that I said earlier? The right to confront. That's a very proactive word, right? That's a strong word. That's an assertive word. To confront the witnesses against us. Not go through some television screen in the other room. We have the right to confront the witnesses. Go ahead. You can say something. So, make the argument for the defense a little bit here. Why is this inadequate? What's so important about confronting the witnesses, and how is this not optimum? How is this not adequate for the defendant? And I would argue, representing the defendant, defective, not a good compromise, and a violation of the Sixth Amendment. Somebody over here. All right, go ahead again. Oh, you.
It contradicts the Sixth Amendment because confront, when you think of confront, you're saying face to face, not through a TV screen.
Yeah, they're not having, they're not having access to, to perform their job duties fully because as a part of defense, they have to ask the victim or witness questions, and they have to get a response for them to build their case up for their to defend the alleged perpetrator.
That's correct. That's right. Well, maybe there ought to be an exception. The Supreme Court said there is an exception. The Supreme Court said you're not entitled to a perfect cross-examination. You're entitled to an adequate cross-examination. You're not entitled to a perfect confrontation, but you're entitled to adequate, constitutionally adequate. Okay? However, the defense makes a good point here. Is there a qualitative difference? And what is it between face-to-face in the same room somebody on a TV screen. What's lost there? Make believe you're the defendant. What do we say if somebody accused you of, and say it's someone you know, say that your neighbor accused you of breaking their Lennox bowl, okay? And her husband said, my wife says you broke her Lennox bowl. She says that? I want to hear her say it where? To my face. She says I broke her Lennox bowl? Let's make it her ex-husband, so that's why he would rat her out. I want to see her say it to my face. There's value in that. There's constitutional value in that. It's important that she say it to my face. And what's the assumption? That if somebody looks you in the eye, that what's going to happen? They're going to tell the truth. What? Or if they lie, they're going to take it back, or they're going to have an explanation, or they're going to say it differently. I mean, that's the kind of thing we might all think of when we hear somebody accuse us of something. Let them say it to my face. So there's an important aspect to being in the same room. Because when you have to look somebody in the eye and make an accusation, it's very difficult. Even if it's true, it's difficult, right? But if it's a lie, then it's not that easy to pull off. It's not that easy to tell a naked, bald-faced lie right in the eyes of the person you're lying about. Very few people, other than the pathological, can do it without some kind of evidence or some kind of behavior that suggests that maybe they're not being entirely credible. And that's what the Sixth Amendment's based upon. And this compromise, where the child gets to sit in the other room because she's scared of dad, and the court says, well, dad can see her, he can judge her, the jury can look at her demeanor, her affect, her behavior. That's part of the Sixth Amendment's right to confront the witnesses. The fact finder, the jury, the decision maker, the jury, needs to look at the witness. Well, they'll get to see her on the monitor, but the other half is missing. The accuser doesn't have to look at the accused. Not under the Crandall model. And that takes away a large part of what the Sixth Amendment's all about. So the defense argued. They lost. They lost because the rights of children and the difficulty to prosecute, specifically in this case, an incest case, the right of the child and the difficulty to prosecute these incest cases was more important than having a perfect cross-examination or a perfect confrontation. So the defendant got to confront her, not as much as he would like to, and the victim got some sense of stability, some sense of being reasonably calm in the other room. Now, so that's an example in New Jersey of the court attempting to level the playing field. New Jersey, especially in the 1990s, the early 1990s, was very progressive when it came to making the courtroom a more hospitable place for kids, a place that kids can feel a little bit more comfortable in, because there's nothing more unnatural and in some ways hostile than a courtroom when you're a witness. Whether you're an adult or a child, it is a highly intense, highly anxious experience to testify in a court. A child is ill-prepared to do that, much less when she has to make an accusation against her dad or someone she loves or trusts or loved and trusted. You see? So that's an example of New Jersey being progressive and respectful of the rights of kids. The Crandall case applies in civil court as well, in any tribunal. It could be a workman's compensation case. any legal proceeding, you can use that setup to kind of tone down the anxiety and the intensity of testifying for kids. And nowadays, remember I told you a couple of weeks ago that very few prosecutors do that, despite all this talk about Crandall. The number one reason was it was a technological nightmare to set that thing up. Sometimes it was just easier to try to put the kid on the regular old witness stand and prosecute the case. I mean, you had to have things like this TV. Look at this TV. It's 40 inches. It weighs about 1,000 pounds. Now we have flat panels. It's so easy to set these things up. You have Skype. You have FaceTime on phones and iPads. And you can connect people across phones in real time as contemplated by the Crandall case, on a $100 budget. But when that case was decided in the early 90s, it was a lot of work to get the technology together and to make sure it works. And so much could go wrong with wires and plugs and radio waves that prosecutors shied from it. Very few prosecutors in the state used it, but it's out there and it can be used. And with modern technology, it's easy to set up and easy to do. Pop a couple nanny cams in, put a kid in another room, roll out a flat panel TV, and you're good to go. All you need is a Wi-Fi connection. Prosecutors also were reluctant to use this method for another reason. And it had to do with how the jury responds to the child's testimony. What is the reason? Imagine you're the prosecutor and your child's going to testify in the manner we just said. Unfortunately, these cases rise and fall solely on the shoulders of children in many cases. There's very little corroboration. We try our best and we try to think and be open-minded when it comes to proving these cases. But in the end, in most of the cases, it's the word of the child that has to convince the jury. And one of the things that the prosecutors didn't like about this and prevented them from using this process in many cases was something about that dynamic and its impact on the child's reception by the jury. Go ahead, Carmen.
Might not be as convincing and not as emotional because she's attached from the whole arena of it, so she might not project exactly what happened to her.
Carmen says the child may not have been as convincing. She might not have been as emotional. She may have been a little detached because she's in the conference room somewhere away from all that's going on. She might not have communicated all of her emotions, and it's those emotions that are convincing to jurors. So you're going to have a kid who presents differently. Yes, that's exactly part of it, and a big part of it. But there's another part of it too that's very related to that. Go ahead.
They might recant.
Well, why would they be any more likely to recant because you're using the television in the conference room setup?
They may not, like you said, they may not feel comfortable, or like some kids may feel like it's very overwhelming and they have to deal with it.
Yeah, that could be. That could be. Well, this is the assumption here is that this makes them feel a little bit better. So, my question is, how does this process affect how persuasive the child is? If this is overwhelming them, then certainly the courtroom would overwhelm them. So I'm looking at something that makes it different in the minds of juries. And the one is the kid's going to appear differently. The kid may not be as emotional, not be as animated, not be as compelling as they might be if they were in court because they're kind of detached. But speaking of detachment, what else might make the kid less effective, though? Let me put it this way. You're in court. The judge is over there. I'm over there. The lawyer's over here. The court officer's over there. All the jurors are over there. We're all in the same room, right? We're all breathing, talking in each other's space. We're all interacting in a variety of ways. Go ahead. That's a very good point, and many child advocates have made that very, very same point. That's a third reason that it might be problematic, and that was pretty astute. Yes, some kids not only the ones who tell us they've been videotaped, but we don't know what kids were in fact videotaped and never told. So to then put them in a room and video record them, it's not a recording, but video project them as part of the process of their testimony might cause all kinds of problems psychologically that we never anticipated. It would not be a good thing to do. You're 100% right. In a case where a kid was exploited by the molester through video recording or other kinds of recordings, or we suspect that they may have been exploited that way. This would be the worst thing to do. Excellent point. The other thing I was driving at is, I used to teach right in this classroom Children and Justice, Forensic Interviewing, and some other class to the students who sat here, and on this TV, and you would see them, was a group in Burlington County? It was some other county college. And there'd be 6 or 7 students in there, and I turn around, and that's what this is all about. This is the distance learning room. I turn around, and that camera, they'd see me on that camera, and we'd see them there, and I'd chat with them, and they'd raise their hand. Do you think there was the same connection between the professor and the students, between me and those students in Burlington and you guys? Yeah, it's a squawking head. I didn't know them. I didn't know them at the end of the year. They were no more meaningful or tangible or three-dimensional to me at the end of the year than they were at the beginning of the year. Yeah, 1 or 2 of them might have stood out a little bit, but you didn't feel there's something qualitatively different about being in the same space with another person. I was reading in Newsweek just this morning about a guy who wrote a book. He's one of these reporters on the national level in Washington. He wrote a book on how people interact socially with one another. And one of the things that he said was about how people, a very basic premise that people need to interact with other people to live happy and fulfilled lives. It's kind of a sociological kind of book. But one of the things that was mentioned in the news article was when people interact with one another, they say that their breathing kind of gets in rhythm, and there's cadences, and there's an interaction, both stated and unstated, between people that make the experience different from just exchanging words. There's a dynamic that happens among individuals who are conversing, whether it be one-on-one or a small group. And there's kind of a rhythm and a synchronization, if you will, that happens. I don't know. I read it today in Newsweek, but the point is, prosecutors were resistant to the Crandall case on the basis of technology, on the basis of, as one colleague called it, the little squawking head on the screen. Remember, the jury got to see the defendant. He's live, he's breathing, he's joking with his lawyer, he's drinking water, he's out in the hallway, he's sitting down, he's hugging his wife. He's real. The court officer's real. He goes in there, he says, hey, you need another pen? Who wants lunch? Everybody's real, they're tangible. And the little girl is something different than that. Now, is the jury going to go, well, we're not going to convict because of that, or we don't believe her? But the psychology of it's important. It's not going to be the same as if that little breathing person got on the witness stand and expressed herself. The feeling among prosecutors was that qualitatively it's different. And I have to agree with that. But some people might not. Other prosecutors have used this method. And you have to weigh all the equities and balance it all out. Now, that's Crandall. Another example of the New Jersey Supreme Court being progressive when it came to the rights of kids in the courtroom is State versus DRH. State versus DRH. That was the medical exam case. And if you recall the facts in that case, there was a finding that was consistent with penetration made by the pediatrician who examined the child on behalf of the prosecutor, on behalf of the government. Okay? So when the defendant was charged, they said, well, here's the evidence. The little girl says it happened. There's some other piece of evidence. There's some other piece of evidence. And here's the doctor's report. The doctor's report says that there are findings consistent with penetration, that there's trauma to the genitalia that's consistent with penetration. This is our expert report. Now the defendant says, that's nice. That's what your expert says. I'm entitled to what? My expert. Bring the little girl. Bring her to the doctor's office, to my expert. Now, from a defense lawyer's perspective, not only is this reasonable, there's no other way to do this. This is the way it works. This is the way it works. If you came in and said, listen, this bullet came from that gun, and we found that gun on your client. You know how we know that this bullet came from that gun? Because we had an FBI expert in ballistics examine that bullet. And there are unique rings that are formed when that bullet exits that barrel. And he evaluated it. He wrote a report on it. He took the bullet to his lab and looked at it under a high-powered microscope, and here's the finding. That bullet in the dead body came from the gun on your back. The defense lawyer goes, well, that's nice. Give me the bullet. I want my expert to look at it. Powder burns, bullets, footprints, forensic orthodontics, all kinds of things that are used as evidence against an accused are subject to examination by the defense expert. There's no exceptions. What are you talking about, man? My guy is going to go to jail for 50 years. I have a right to get that evidence examined. And not just because that's the way it's always been done. Not just because that's the way we do things, and I have a right, what's good for you is good for me. But there is a basis in the law for this. What constitutional provision allows the defendant to look at bullets and footprints and teeth marks and get their own expert to look at them? What one? No. What constitutional provision have we been talking about? The Sixth Amendment. And what does the Sixth Amendment guarantee an accused? The right to do what? Confront the witnesses against you. Somebody explain to me how getting your own expert to look at the bullet or to look at the little girl's genitalia or the footprint or the teeth marks is confronting the witness against you. It is. Tell me why. Go ahead, Miguel. What? Who are we challenging? Whose report? Yes. The expert has opined. The expert has given an opinion. The expert has looked at the bullet or looked at the little girl's genitalia, and they've concluded something. Much the same way that Anne Boleyn had to sit in that chair and be prosecuted and ultimately convicted on the basis of this stack of papers that were supposedly the statements of people who knew what she did. Right? This report is a piece of evidence that the prosecution relies on to convict the defendant. He wants to challenge. That's a witness. Not yet. It's his report or her report. She will come to court. And that witness needs to be challenged. It's not only important, it's a fundamental right in the United States of America. You have the right to confront witnesses. You're not allowed to bring in your FBI guy and go, no, you can't get your own expert. There's a constitutional right that says we can, and we will. Go ahead.
But even if it's traumatizing for this little girl to have another gynecological exam, that would...
Well, that's the issue, isn't it? That's the balancing fact. The prosecutor had another position, right? That's the whole point. The prosecutor said no. The government said no. We've already had the child examined, and our expert in the defense goes, I don't care, man. I got a right to challenge the witnesses. The health, look, we don't want to see children get traumatized. We don't want to see them get hurt. We don't want to see them get emotionally scarred. But my guy don't want to go to jail for 50 years either, and he didn't do it. He didn't do it, and despite all of the negative and bad and hurtful things that might happen to that child, not one of them is in the Constitution of this country. Not one of them is recognized by this court as being the law of the land, as being a paramount principle upon which our country was built. No, we don't want to hurt kids, and kids got a right to live a life free of trauma and sadness. But my client has a constitutional right. I might not have said this earlier. It's the law of all laws. that's passed by any other legislature, whether it's the Congress or the state of New Jersey's legislature, cannot conflict with the Constitution. It's the law of all laws. The supreme law of the land. Thank you. So while there is probably unanimity among everyone in New Jersey that little kids ought not get traumatized or be emotionally hurt in any way, shape, or form, you know, my guy's looking at 50 years, and he has a constitutional provision that says he's got the right to confront witnesses. What did the court rule? Did they say, bring her down to the doctor and have her examined?
No.
Go ahead,
If
Carlos.
she didn't want to do it, then they dismissed the charges.
Well, no, it wasn't about whether she wanted to do it. The court said,
The fact that she refused to go for another exam,
did the court allow the defendant to get an independent exam of the child? No.
no, he did.
No.
Okay.
The lesson of the case is the defense does not have an automatic right to an exam of the child, like they have with bullets and teeth, and feet, and footprints. No. They gave us a test, though. Here, let me take a look at what you read. The victim didn't want to go through another exam. Oh, you're looking at the trial court. The trial court dismissed the indictment because of the Sixth Amendment. The trial court said, hey, we got the Sixth Amendment. But this is the Supreme Court now, so you got to look at the end of the story.
This is the DRH?
DRH, yeah. I'll show you. It accordingly is required that there be a substantial showing of need and justification by the defendant. The inquiry into whether a defendant charged with sexual abuse of the child has a substantial need for physical exam of the child must focus on the likelihood that the exam will produce competent and probative evidence. Consequently, we hold, and this is the key, when you hear the court say hold, that means we decide. This is our decision. We hold that courts may order the physical examination of a child sexual abuse victim only when satisfied that the defendant has made a sufficient showing that such an exam can produce competent evidence that has substantial probative worth, and if admitted and believed by the trier of the fact, that evidence could refute the prosecution's evidence and impugn the credibility of the witness. So the answer is, as a defendant, the door is not completely shut, but it's very difficult. You have to show that you're going to get some different result. And you have to show it persuasively, based upon evidence and based upon expert testimony, that your expert will find something different. Again, the court can order a second exam only when satisfied that there's a sufficient showing. And when they use words like substantial, that means it's hard to do. You have to show substantial probative worth. Then they looked at this guy. So they announced a new rule. And the rule is, this is the new rule. You don't get a second exam of the child. That's what this case says. Unless there's a substantial basis for it. And you need to be able to express that. And there hasn't been a second medical exam, as far as I know, in New Jersey since this case. Ever. Which goes to show you, you really got to show something different. Okay? So then they looked at this case here. And I'm pretty sure in the end, they said that DRH, Moreover, there's been no suggestion that, given the results of the first exam, a medical doctor testifying on behalf of the defendant could not credibly and persuasively challenge the conclusions of the state's doctor. So, thank you. So, despite the fact that there are serious Sixth Amendment implications, the defense does not have an absolute right to get a second exam. To the contrary, it's unlikely that they will get a second exam, and they need to show a substantial need. Okay? A substantial and substantial evidence that the examination will tell something different than the state's doctor. Go ahead. I can't hear you. What you say? I know what you're referring to, and there wouldn't be a sexual assault exam done. Well, I think you're going to find that the outcomes will be a lot different if there's an examination of an exhumed body, because there you don't have to worry about trauma or anything. The defense is going to have a right to get its own piece of bone fragment or hair or whatever it is that the state plucked out of the earth. The defense should be equally able to get a sample and do that kind of exam. The critical issue here is whether we're going to allow kids to be re-traumatized by a second medical exam in order to effectuate the defendant's right to confront the witnesses. And how do we balance that? Here, we shut the door on it. There isn't going to be, you're not going to, well, we didn't shut the door on it. Let me say that differently. The court makes a good point, an important point about that. Unless you can show that your doctor will come to a different conclusion, then you're not getting it done. That's the rule. It's not happening. And you still can confront the witnesses by interviewing that doctor, by listening to their testimony, by having their own doctor read that report, look at the findings of that doctor, and in modern forensic pediatrics, and Dr. Finkel doesn't like when I call it forensic pediatrics, but that's what it is, in some sense. This is pretty much a moot issue. Did I post a podcast I did with Dr. Martin Finkel? Did you listen to that? A podcast where I interviewed Dr. Finkel from South Jersey? Is that something you know? On the learning modules?
It's in the discussion.
Oh, forgetting about whether it's, you can click on it, it works. I'll fix that. Is it among the things that you need to do?
Yes.
Okay. One of the things that Dr. Finkel will tell you is that the modern pediatrician who evaluates sexually abused kids uses an instrument. Does someone know what the name of that instrument is or what it does? You CPS workers? A colposcope? Have you heard of a colposcope? A colposcope is just a camera, but it's a high-powered camera, and it's really a medical instrument that takes extreme close-ups of children's, anybody's genitalia, but in forensic pediatrics, of children's genitalia. So you will have now, when was this case decided, Carmen? Approximately, what's the date?
1988.
88.
88, I mean, yeah.
Yeah, in 2011, you got these colposcopic photos. So you can share the photos with the defense expert. So there is a record of what the doctor saw. And in fact, the doctor, any credible, respectable doctor who does pediatrics in 2011 doesn't want to see the kid anyway. They just want to see the colposcopic pictures. That's more than enough. In fact, if Dr. Finkel was practicing with Dr. Thaddeus, and Dr. Thaddeus practiced about a block away, Dr. Thaddeus would say, I don't want to see the kid again, just give me the colposcopic pictures. And you look at them and you draw a conclusion. So nowadays, DRH is not even that relevant.
And this was 3 years later. The kid was 12, according to this. It was 3 years later, and both the stuff that would have altered the examination.
Well, yeah, Carmen makes another point here, and it's a very important one. 3 years later, the defense doctor wants to do an exam. The kids heal. The likelihood of findings are very low 3 years later. Although the state's doctor saw something, so who knows? But you have these high-powered images now. That
But those images sound pornographic.
I've seen hundreds of these images. They're not titillating in the least bit, or pornographic. They're like looking at the. You ever my wife Darlene would watch now and then those medical shows that were really gruesome, where they're like doing operations and stuff. I couldn't even look at it. These are just close-ups of tissue. You don't even know what it is. If you looked at these giant photos, you don't know that it's a vagina. It looks like a, I don't even want to tell you. It's like red tissue. So it's not. It's not. It sounds like you got a camera, you're taking pictures. It's nothing like that at all. There's nothing like that. Okay. Next we have State versus RW. Is that a case that involves the confrontation clause? That's the psychological evaluation case. This case did not involve the right to confront witnesses as directly as DRH and Crandall. But if you recall, has someone read the case recently? How old was the kid in this case? Well, it wasn't an infant. She was an infant in the law. They call her an infant, but I mean she's not a. She was verbal. She's well, how old? 3 years old. Yeah. So she was able to be verbal, but I'm sure she couldn't speak in a good narrative. But the prosecution intended on using her on the witness stand, and whatever she had said formed the basis and part of the prosecution. And the defense said, "Wait a minute. You're going to convict my guy with a 3-year-old? I have a right to have a psychological evaluation on a kid to see whether she's competent or whether she's got problems with being an accurate historian or being able to express past events. I want my own doctor to evaluate her." The prosecution didn't have a doctor in this case. It wasn't one of those things. This was just the defense saying the child is so little. She's going to be a witness against my guy. I want to get her examined to make sure she's able to tell the truth, to express herself in a narrative. And what did the court say?
They talked to her. I remember they asked her questions and she was competent to answer questions.
Yes, Carmen, you're right. The court found that she was testimonially competent. And they also said that there is no automatic right, just like with the key words are automatic here, to a psychological exam, even if a child's only 3, or even if we have concerns about their ability or their competence. Okay? Every person is presumed competent, unless you can demonstrate that they're not. And I think, may I look at your pronouncement? All the gadgetry I play with and all the technological toys I have, nothing better than a piece of paper with some yellow highlight on it. Right there on the table, like Carmen has. I love Carmen prints everything out. That's okay. Nothing wrong with that. And it's ideal right now, right? 3-year-old daughter. That's the victim. 3 years old. The suggestion was the prosecution was for intercourse. No physical evidence, as usual. And
She understood lying. She understood right from wrong.
Yes.
She was interviewed.
Here's the holding of the court. There must be a substantial need by the defense in order to qualify for a psychological test to determine competency. There must be a substantial need for the examination. substantial need, there must be a showing of some deviation from acceptable norms, such as an identifiable or clinical, psychiatric, or similar disorder, beyond the realm of those human conditions that ordinary experience would consider normal. So to put it in layman's terms, but you still need to remember you need a substantial need. You don't have a right to automatic competency, psychiatric or psychological evaluation, unless the defendant can show a substantial need. And substantial need means the witness is different from other witnesses that are similar. If you have a 3-year-old, you need to show that that 3-year-old is somehow different from the normal 3-year-old. For example, some kind of clinical disorder or clinical problem with that child, more than those that would be considered normal. And the court says earlier that all witnesses are assumed to be competent, even 3-year-olds. So in order to get a psychological evaluation, you need to show that that 3-year-old is different in some way. There's a substantial need that there's some deviation from the average 3-year-old, and that there's some indication. Now, this court said about this kid, and it shows you how now they apply it. They make this rule and then they apply it. They go, the only support for the defendant's motion was alleging that the victim was mentally immature, has a vivid imagination, and is subject to flights of fancy, and that he had observed the complainant. This is where credibility is completely lost. He observed that the complainant, this is the lawyer talking on behalf of his client, he had observed the complainant had fantasies concerning sexual contact and relationships. Oh, I see. I thought it was this case. This is a Colorado case. I'm saying this guy's got a straight face. He's saying that the 3-year-old has fantasies about sex. The appellate division determined that they needed to send the case back to the trial court to permit the defendant to get a psychiatric exam. This court said no. While it might have been appropriate to have given the defendant an opportunity to present evidence, no such evidence was offered at the trial level. So they're sending it back to the trial court to decide. That was the outcome here. Whether this kid would have been examined and to apply the new standard. And the new standard is, as I expressed it earlier, that there be a substantial need, right? Substantial need, some deviation from normal behavior. So, again, this is good for kids, because just because you're 3 or 4 doesn't mean you got to get evaluated by a doctor. Okay? So age alone doesn't determine whether you need to get evaluated. Now, the last case...
Can I ask you something?
Yeah, go ahead. Sure, of course.
I know the discussion board that we had last week.
Yes.
It talked about tainted hearing.
A taint hearing, yes.
Will that apply today on this way, instead of subjecting the kid to having psychological, maybe they try to find out whether this kid is competent based on that taint hearing, or how will that apply here?
Yeah, well, we're going to talk about taint hearings next week. But Teddy's asking whether the taint hearing might now be involved in this kind of decision about whether the child's competent or not. And I think you're right. Now with a 3-year-old, you may get your day in court and your expert when you have one of these taint hearings, when you have very small, as they call them, infant children. but they're referring to even preschoolers and toddlers. The taint hearing we'll look at next week, but that evaluates the child and their ability to remember things and the potential for them to be influenced by the adults who ask her questions. And yeah, these issues kind of dovetail and interconnect. The last case that involves the Sixth Amendment right to confrontation and also involves kids in the courtroom is KAW. Somebody tell me what KAW is all about. You guys know this one. This one is something that happens all the time. KAW. It's actually a juvenile case, I believe. I'll give you a clue. Carmen, I know Carmen. Now I don't want to hear from Carmen right now. Not because I don't respect her response, but she does a lot of answering. Somebody else got to step up. You're doing a good job. Let someone else do a good job. Go ahead.
What was the case where they were trying to say that because
Yeah, this is the children in dates case. The children in dates case. And when you charge someone with a crime, there's a box on the criminal complaint where you put the date of the crime. You put the date that the thing happened, the date that the offense occurred. Well, in the KAW case, the child was unable to recall precisely when it happened. In fact, it was a multiple abuse case. I'm not sure if it was a chronic case and that it happened over a period of years, but I know it happened on multiple occasions, lots of different occasions. And the child could not pinpoint with any degree of precision when it happened. And the complaint was vague about that. And the person that was charged said, wait a minute. You can't convict me. You got a Sixth Amendment problem here. How is there a Sixth Amendment problem? Let's start at the beginning. What's the Sixth Amendment require that we do? We have the right to confront the witnesses against us. In order to confront the witnesses against us, we need to know what is, what the charges are, what we're accused of, right? Yeah. And when it happened is part of the charges, right? It's not only what happened, it's when it happened. Because the Sixth Amendment requires notice so that we can prepare a what for accused? We can prepare a defense. We can prepare a defense. We can say whether we did it or not. We can say, wait a minute, I was in Florida during that time period. Or I wasn't her babysitter then. Whatever your defense is. Notice that the charges allows you to begin thinking about what your defense is, and if you have a defense. So in order to confront the witnesses against you, you need to know what they say you did. That's part of the Sixth Amendment's confrontation right. What did they say I did? And equally important to what is when. So in this case, there was no when. The defendant said, dismiss the case. It is a fundamental part of my rights under the Constitution that I be told what the charges are. And you're not telling me what the charges are. Oh, yes, you say what the acts are, but I don't know when they happen. And if I don't know when they happen, I haven't been informed. And if I'm not informed, I cannot confront the charges against me. I can't confront the witness. I can't. You're not telling me when this happened. That's what they did in Anne Boleyn's time. They didn't tell you when, or who, or what. And here you get a little bit of it, but not all of it. But the court was very progressive again and said, well, we need to do this balancing one more time. We need to do this balancing one more time. And the prosecution has an obligation. What's their obligation, the prosecution? Can you just say, sometime in the 1990s? Say it more loudly.
To give me a period of time or dates.
Well, yeah, to give a period of time or dates, but how do you get there? the prosecution has an obligation to try to narrow the time frame. And you can give a period of time or dates. But you have an obligation to try to narrow the time frame. Just because the witness, in this case a child, has a hard time remembering, doesn't mean that's the end of the issue because it's a little kid and they have a hard time remembering. We're just going to leave it at that. You still have an obligation to question that witness and look at the objective evidence and try to narrow the time frame. There is an obligation. You just can't mail it in on this issue. You've got to be diligent. However, the court recognized that children do not remember dates like adults do. They do not live their lives according to the clock or calendar like adults do. They further recognized that with chronic or repeat abuse, it blurs the recollection. It makes it difficult to remember when any particular or discrete incident occurred. The court also recognized that children do not understand or have a sense of chronology or sequence like adults do. To put it simply, they have a hard time with time. Time is a developing concept to kids. So we're not going to let the defendant benefit from that. We're going to be fair and hospitable to kids in New Jersey when it comes to when the abuse happened. We're going to allow the complaints to charge a period of time or a group of time or a section of time or a period of time. But there's a corollary, a related obligation by the prosecutor to try to narrow it as much as they can. And if you can't narrow it enough, then the charges get thrown out. But if you can, you can still charge a period of time. And it will be prosecutable. It's relevant if the case involves a potential alibi. So if the defendant says, I know you charged between January and December 1996, but for 4 of those months I was living in Waikiki, Hawaii. I got to know when it was because I have a defense for that time. If alibi means you weren't at the place that the thing happened, so it couldn't be you. That's an alibi. You have an alibi. An alibi sounds sinister, bad, negative. No, an alibi is good. If you're accused of something, you have an alibi. That simply means where the thing happened, I wasn't there, and I got proof. And if I wasn't there, I didn't do it. An alibi is a real good thing to have. And if you have the potential for an alibi, the court is going to require that you narrow the dates even more. They will be more liberal if it's a case in which there is not going to be an alibi. Now, you just can't make it up. Well, I could have an alibi if I wanted to. You know why? A lot of these cases involve incest or family abuse. There ain't no alibi then. The dad lives with the kid's whole life. So alibi is not even in the picture. And in most of these incest or quasi or incest-like offenses or intrafamilial abuse cases, alibi is not even relevant. And you can plead or charge a span of years or a span of time. That's the word I was looking for before when I was stumbling. Period. Grouping. A span of time. You can charge a span of time. As long as you attempt to narrow it down. And there are lots of different ways to narrow it down. Someone who hasn't spoken today, tell me how you would narrow the time period down if you're dealing with a little kid. What are some? Well, the summer is, you could put the summer in the charges, but you've spoken a few times, and I want to know, how do you get the summer from the kid? How do you ask? The kid's having a tough time telling you when it happened. What are some strategies to narrow the time period? Go ahead. can ask about school, because school, you know, whatever you learn about school, if it was during spring break or it was during the time when the the jungle gym was broken, or it was during the time when Mr. Jones was my teacher. Because school is something that's very important to kids, something they're very connected with, that's a very good thing to use as an anchor or as a mark, if you will, of when something happens. So if you can connect it to something about their school life, that's real good. And that's more likely to work because they're in school. And school's important. And school's a big part of the day. It could be anything, like you said. It could be, what did you say?
I just said if you could connect it to whether they were in school or not.
Or whether they were in school or not. Yeah. Well, if they were in school, so now we got from September to June. But we can narrow it down even more, and that's what the prosecutor needs to do. You can do it. You can narrow it down to whether they were in school during that day, or it was after school, or if it was on the day. Yeah, what the weather was like. What was that? Holidays, Christmas. We're coming up on Easter in Christian religion. Easter, Passover, whatever holidays, Ramadan, whatever might be relevant or connect with that child, bring it up. It was around this time, or just after that time. So these kind of landmarks in time, holidays, summer break, school, another example of something that might be relevant to you. Yes, that's a good one for boys or girls if they're in after-school activities, if they're in sports, if they're in cheering, if they're in softball, baseball, basketball, whatever. And we know when they play those things too. If he was wrestling at the time, we know when wrestling season is. Okay, that kind of narrows it down. It was during wrestling season when I was in the 6th grade. So now we took the 6th grade and narrowed it down to those 3 months or whatever it is that's wrestling. I'm sorry, who said something? Yeah, a family event, a death, a birth, a marriage. Where they lived. You will see that some kids, even when they're 5 or 6, may have lived in 3 different houses. They might have lived with grandma for a little while, then they moved to their own place, then they had to move out of there because of A, B, or C, then move somewhere else. So if you can narrow it to the time they were wrestling at the house on Market Street, now you know when they... And the key is, if they can talk about things that are relevant to them, you don't need to go, well, when did you live on Market Street? Get that from the mother, man. You only have so many questions to ask in an interview. Don't start asking about when to them. Just find out what was relevant to them. It was when I was wrestling. We could find out from the school when he wrestled. We don't need to start pestering the kid with follow-up questions. So if the kid was when Grandma lived on Market Street, we could find out from records or from Grandma herself. Those are things. I'll give you some quick examples, then we'll go what I've done in the past. One little girl talked about the top she had on. It had a starburst, a sun starburst on it. She always loved it. And her mother knew when she bought that top. So I knew when it wasn't. I didn't know when it was, but I knew that it was. We know that she bought the top, let's say Easter of 1997. We know that it wasn't February of 97 or 96 or 95 or 94. So we got a baseline. The girl owned the top, right? And then we kind of moved from that perspective. I had another case where the freeholder's husband in Passaic County molested the granddaughter. She was 4 or 5, she was from 3 to 6. She remembered the bike she had. She remembered the bike. In fact, the perpetrator bought her the bike with the banana seat and the bell. So it was when I had the bike with the banana seat and the bell. And you may find this helpful. I learned this from that case. But kids some of them go through a series of different bikes. I know I had a lot of different bikes growing up. Broken down bikes, nice bikes, bikes that got stolen, bikes I gave away, traded, whatever. And then you grow up and you have different cars, and things. But they are snapshots of certain times in our lives. Same thing with little kids. They may have a certain toy or a certain thing in their life. And this girl remembered was when she had the bike with the banana seat, the bell, and the basket. And Mom said, oh, I know when we got that bike. We gave it to her on her, blah, blah, birthday. So now I knew it had to be after that time. We know when the bike was purchased after that time. And it's limitless. If you just be, I don't know if creative is the right word, but just be diligent. Go ahead.
When I was molested either, I was
relevant, or a movie, or any pop culture. Again, we can identify when these pop culture events occurred. You know, if they were watching Steve Harvey, you know, we know when it went in reruns, we know when it was on first run, you know, so we can, couple of things here. If they were watching Steve Harvey, we know that that went on at 7:30, let's say, on syndication on UPN. I have no idea what went on. But if that's what it was, we can figure that out. So it tells us a couple of things. What time of day during the day, and it also tells us it was when Steve Harvey was on, which isn't on anymore. But we know when it was broadcast. Excuse me. Yeah, someone else? But yes, that's an excellent one. Any others? What was that? Yeah, who your best friend was. Was she still your best friend? Who was your best friend at the time? Did you tell a best friend? No, but if you could have told the best friend, who would you tell at that time? Kids probably go through best friends more than they go through bikes, shirts. So that's a very good one. One I never really thought about, so I like that one. Any others? Yeah, go ahead. Well, how does that give us time, though? If they change their bedroom, if their bedroom decor changed? Ah, now I know what you're driving at. Yes, yes. That would work well with an adolescent and delayed disclosure. Let's say a kid who's 16 or 18 says, when I was little, my father molested me. I don't know. It seemed like every day. Well, was it when you had the Barbie bedroom or the My Little Ponies on the wall or whatever it is? You know, that's the little ones, or, you know, was it Justin Bieber, or was it, you know, I don't know who's Lenny Kravitz, I think. All right, we'll see you next week.